Well, good afternoon, everybody. This is Brian Horlick, and I want to welcome you to our weekly AMA, Ask Me Anything, where it is your opportunity to get all of the current condominium information, condominium law information, dealing with everything and anything in the condo industry, COVID-19, updated case law, answering all your questions. So we're back again. We took a week off last week to regenerate ourselves. We've been doing this since, I guess, about March the 17th, when COVID first became the pandemic that it is. It's a bit disappointing, unfortunately, that, as we went through and we did these AMAs, and the longer we did them, the more COVID seemed to be under control, the less cases there seemed to be, and the happier everybody was. And now we have a turn of events where COVID is making a resurgence in a big way and is getting worse, and the government is concerned with the upcoming flu season, people staying indoors, that we'll be getting maybe 1,000 cases a day. So that's pretty disheartening, and we seem to be going back to where we were. Just give me 1 second, please. Where's Barack? Go get him, please, right now. Go get him right now. Okay, we have, all right, I thought we had a comment here that I was muted, but now there's a comment that it wasn't me who was muted, but in fact it was someone who's listening that was muted. All right, Harlan Stafus, we forgive you. So as I was saying, the COVID-19 seems to be coming back with a vengeance. Disappointing for all. We have to maintain our social distance, wash our hands, and really listen to the medical authorities. So what's been happening in the world of condos since I was last with you 2 weeks ago? Well, the declared emergency, as we know, was rescinded going back July the 24th. The amendments to the Condominium Act set out that a number of temporary suspensions in the Condominium Act would be in place until November 21. Specifically, was the issue of electronic meetings and electronic voting. And as many of us now know, certain provisions, including those, have now been extended from November 21 till May 31st. So that's a bit of good news for all of the condominiums out there who are wanting to pass electronic voting bylaws. Unfortunately, the period of suspension by which AGMs had to be done, which is by November 21, that's the revocation date, the suspension date, that has not changed. And so therefore, your AGMs have to be done by November 21st if they fell within the period of the pandemic. They would have to be done within 90 days from the end of the emergency order, or 120 days, depending upon whether your AGM fell in July. So good and bad. The good news is that for electronic voting and virtual meeting bylaws, you won't need them in place until after May 31st. Very importantly, if you haven't already had one drafted, now is the time to draft your electronic voting and virtual meeting bylaw, so that when May 31st comes along, if you want to have a virtual meeting, or if you must have a virtual meeting after May 31st, 2021, you already have your bylaw in place, and you will be able to call your owners meetings, your AGMs, and of course your requisition meetings to remove your board members, because what would condominium living be if we couldn't requisition the removal of volunteers who are spending a lot of time and effort trying to assist the corporation, and here we go, sending out requisitions to remove them. All right, so that's what's going on. That's the latest and the greatest. I will tell you that just going back to the moving of the suspensions from November 21st to May the 31st, 2021, the following things are in addition to what I said about the bylaws as far as the extension time. So, number one, we all know that during the suspension period of time, one of the amendments to the Condominium Act dealt with meetings of directors. The directors were able to meet by electronic means or by telephonic means without the necessity for all board members to unanimously agree, and that was part of the suspension. And now that the ability to have board meetings and to have them electronically or by telephonic means has now been advanced until May 31st, 2021. So up until May 31st, 2021, you don't need unanimous consent of all board members to have a board meeting electronically or by telephonic means. In addition to that, you have the ability right now, if you are establishing electronically a communications link to a virtual meeting, the fact that you establish the communication link is added to the quorum for the attendance at the meeting. In other words, if you're going to have a virtual meeting and somebody registers for the meeting but actually does not vote at the meeting or does not, quote unquote, attend the meeting, the fact that they registered for it is an electronic link, and that counts to the quorum. So moving forward, I believe that the electronic submission of proxies is going to go the way of the dinosaur, I believe, because for AGMs and other owner meetings, you can always use your paper proxies, and electronically, if you register for the meeting, you're deemed to be in the meeting for quorum purposes, and you will get an electronic link to vote. So my question is, why would you submit a proxy electronically when you can, instead of submitting a proxy, you can actually vote electronically and you don't have to be at the meeting, provided you've registered. The other thing is, as far as the moving forward with the date to May 31st, service by electronic means continues up until May 31st, 2021. So as you know, in order for owners to be served with certain type of documents, the owners have to enter into an agreement with the condo corporation that they have to sign. During the pandemic and now up until May 2021, you don't need to have owners sign the document. If they haven't signed it, you can still serve them electronically. So these are some of the things that are continuing with the extension of the suspension period to May 31st, 2021. Unfortunately, and it's a big unfortunately, the AGM period has not been extended. We have sent out an FAQ. We do that every Monday or Tuesday, depending upon how hot the news is, because if we know that Premier Ford is making announcements Tuesday, we will send out our FAQ on Tuesday so that we are fully current. But in our FAQ, there's a whole table there that sets out, based on when your year end is, when your AGM should have been, and what it is going to be in 2020, and how it's going to be affected in 2021. So take a look at the FAQ, take a look at the table, and you will see exactly what you have to do. I will tell you that, as many of you know, our office has instituted and secured a state-of-the-art electronic voting software platform. We are now providing the service called HLD meetings, and we are hosting and we are chairing virtual meetings with electronic voting. I can tell you it's been a tremendous success in the condominium industry. Our phones are ringing day and night for condo managers and board members calling us, actually begging and pleading with us to provide them with a date for their AGM. So I'm starting to feel quite popular in my practice. It's very active. It's sort of, I feel like I'm a maitre d' at a restaurant, and people come to the door and say, I'd like a table for two, and we don't have a table. So you tell the person we don't have a table, and they look at you and say, come on, you got a table for me. So that's sort of what's happening with the meetings, Everybody's calling and saying, hey, so-and-so, I'm a friend of so-and-so's. He said I should call you. You got a meeting for me. So it's like I should be wearing a raincoat, and under my raincoat I have got meetings for sale. All right, what else is going on? Well, the social gatherings have been reduced, as we all know, from a resounding 50 people to 10 people. So those few corporations that decided to have in-person AGMs, keeping the attendance maximum at 50, they've done them. Others who wanted to cannot, because again, the maximum capacity for the social settings is 10 people or 50 people outside. Or rather, it's 10 people inside and 25 people outside. So it's really not effective for in-person AGMs. We have had a few clients that have done AGMs to date, and they had mixed success. I think the majority of the clients are moving forward and have been moving forward with electronic meetings. I will tell you our experience to date is the boards and the managers, while very, very reluctant and hesitant and actually quite anxious about having a virtual meeting, when it's all said and done, our experience has been very positive. The managers and the boards are saying, wow, that was smooth, that went well, and maybe we should try this next year as a way to increase owner participation. So moving forward, one day when the pandemic is done, perhaps we will see the norm being AGMs and owners meetings being held both virtually and in person. And hopefully that will encourage many of the owners that really do not want to or cannot find the time to participate in their community, which is really essential for condominium living. The difference between a building and a home is participation in your community. So we have, as I said, the FAQ. There's a whole bunch of questions that have been written out with answers, and you should take a look at that to keep up to date with everything to deal with meetings and condos. Now, moving on, we had recently discussed, and I'm just going to mention it briefly, there was a case dealing with Sharon Fraser. She is an owner of a condominium corporation, and that condo corporation, due to COVID-19, passed a policy, and the policy said that unless renovations were essential, they could not be done during the pandemic. And Sharon Fraser had some water damage in her unit and wanted to fix her flooring. The corporation said, well, you can't do it. It's not of an urgent nature. It's not essential. And she wasn't happy with that. And after a while, she just told her contractor, okay, go in and do my floors. And the condo corporation brought an application in court to prohibit the contractor from repairing the flooring. And the condo corporation was successful. Now, what's interesting in the case is that the judge looked at the policy being that there could be no in-suite renovations unless they were urgent or essential, found that the policy was reasonable, and likened the policy to the board's ability to pass rules in a condominium. So as we all know, boards are entitled to have rules drafted, and rules deal with safety and security and health. And when you do draft a rule, you have to send the rule out to the condominium corporation owners, and the owners have the ability, if they so desire, to requisition a meeting on the rules and to have a vote, yay or nay, on the rule. Now, in this situation, in the Fraser case, what the judge dealt with was a policy. And it wasn't a rule, but the judge looked at the policy and said that the policy was sort of akin to a rule. It was part and parcel of the rule-making authority of a condominium, which is very interesting because, as a condo corporation, that's a great thing. But from an owner perspective, from an owner who may not be particularly enthusiastic about the policy, there was no ability for the owner or a group of owners to requisition a meeting and say, well, we don't like your policy and we want to have a vote. And if we have a vote, we want to vote against your policy. So interesting, the judge said that the policy was not absolute, and it dealt with matters of emergency or health risks. So in this particular condominium community, there were a number of people that were seniors, they were advanced in age, there were people that had compromised immunity systems. So that community was, let's say, a more senior community, and perhaps the judge was influenced by that. The judge did say that a policy has to be reasonable, just like a rule, and if the policy is in place longer than it's necessary or needed, it would then become unreasonable. Now, the judge also said that the corporation put in place the policy which was to address the health and safety of residents. The judge found the policy to be a reasonable exercise of the corporation's rule-making powers. So I bring this up because in our practice, one of the questions that has come up is, well, if we make a policy, is it enforceable? And according to the Fraser decision, the answer is yes. It is enforceable, and it can be enforced in the same manner as a rule. The other issue that we seem to be facing deals with wearing face coverings and masks. There are the will never wear a mask group of people, and there are the other group of people that say we want to wear a mask and we want everybody else to wear a mask because A, it is the law. The law requires that people who are entering the condominiums, people who are in the enclosed common spaces must wear a face covering or a mask. That's a City of Toronto bylaw. That's a provision in the province of Ontario. And so those bylaws need to be upheld and enforced by the condo corporations. Condo corporations are required to have a policy dealing with face coverings and masks, again, in the enclosed common spaces. So the question becomes, what happens when people don't wear masks? And the other question that keeps coming up is, do we have to wear masks in our amenity areas? Do we have to wear masks in our fitness facility areas? Now, there are a number of condo corporations who have yet to open their amenities. And as the Fraser case will show you, the condo corporations have the ability to pass rules and to make policies that are more stringent than the requirements of the City of Toronto or the province of Ontario. So the minimum requirement is set out in the policies, in the bylaws and the orders of the health authorities in Ontario. Those are the minimum requirements, but condo corporations are very, very able to make more stringent requirements. So we'll talk for a moment about the fitness facilities. If you look at the City of Toronto bylaw in particular, there's a provision there that although people have to wear face coverings and masks in enclosed public spaces, there is a provision there dealing with fitness facilities. And there's something there that says the policy shall permit the temporary removal of a mask or face covering where necessary for the purpose of receiving services or while actively engaging in an athletic or fitness activity. So City of Toronto bylaw for, let's say, quote unquote, enclosed public places such as a gym, a public gym, they say that you can take the mask off while engaging in athletic or fitness activity. A question that keeps coming up in the condominium area is, can we enforce the mask or the face covering policy in our fitness area? And I'm going to say the answer is yes. And the answer is yes because the City of Toronto bylaw, as amended, dealing with condos, does not differentiate between any amenity rooms. The mask policy face covering deals specifically with enclosed common areas of the condo building, enclosed common areas. So your fitness area, it's a common area, it's a common element, it's enclosed. So the answer is you are required to wear a mask. That's the law, that's the City of Toronto bylaw. And of course, condominium corporations, as I said, are able to make their own policies and rules which are greater and more stringent than the Ontario government and the City of Toronto. So let's go to a few questions and then we'll get back to a few more interesting tidbits. So, Marian Hamill, we have our virtual AGM scheduled for next week. What happens if we do not have a quorum? Well, Marian, if you don't have a quorum, you cannot move forward with your meeting. You need to have 25%, and 25% are the owners represented by paper proxy, by electronic proxy if you have electronic submission of proxies, and by those that have registered for the meeting. So under the Condominium Act, you are able to, again, have electronic meetings. You're able to vote electronically as well. And there's a provision in the Act that says, dealing with quorum, once you have established your electronic communication link with the meeting, you're added to the quorum. So if you don't have a quorum, you're not going to be able to move forward with your meeting. But I will tell you that you need to do as much as you can to send out more invitations. If you're doing it, to whomever your service provider is, should start sending out, the links on a more frequent basis, and hopefully you'll have your quorum. We have a question from Harlan Stavis, who originally said I was on mute and he scared me, so maybe we should just ignore him today. But no, I think we'll we'll read his question and then we'll ignore him. Do all virtual AGMs that you chair include a sax recital? That's Harlan Stavis, so we are going to ignore him. Catherine Barbolini, our garage falls under the authority of the shared facilities. An owner is purchasing an electric vehicle. No infrastructure review has been conducted. The committee is not prepared to conduct the review unless the owner pays for this. I don't think this is permissible. Is this allowed? Any advice? Today owners have a streamlined process in order to move forward with electric vehicle charging systems. You can download certain of the costs to the owner in the application process. You have to draft your documentation properly. I don't think that it's going to fly to put all of the costs, which could be excessive and unreasonable, onto the owner, which could result in the denial or the not going forward for the electric vehicle charging system. And so there's a whole process there where there's a denial and there has to be an appropriate reason. It's all set out in the legislation. I think that the committee would be going down the wrong path if the cost to get the charging system is excessive. So Nita G, hi Brian, how are you? Nita, how are you doing? Nita is managing down at the water, at the lakefront. And I tell you, it's we used to be great to go down to the lake, and I think lots of people are now staying home due to the pandemic. We look forward to going down to the lake, Nita, to see your beautiful condominium one day. Eleanor Bahidi. Hi, Brian. Glad I was able to be at this live stream today. Just wanted to give you some feedback on the virtual AGM we just had with your team, which went extremely well. Thank you for planning it so well. Eleanor, you're very welcome. So let me just say, on the topic of virtual AGMs, what's really important, and I said it before, everybody is nervous. The condo managers are, highly anxious. The regionals are anxious. The directors are anxious. And it's our job to do a great job, make sure that nobody's anxious. What we do is we do a small rehearsal. We prepare in advance. I hate to say it, but it's just like a wedding. And the rehearsal goes well. We answer all the questions. And at the end of the day, it goes smooth. And everybody is shocked how painless it was. So, Eleanor, thanks for the good feedback. Next, Leo Alvarez. Hi, Brian. Can board meeting minutes be signed electronically due to COVID, or do we need wet ink signatures? Well, the meetings can be signed. I'm going to suggest electronically should be fine. There's a whole process in place now for electronic meetings of board members, virtual meetings, telephonic meetings. So either you can electronically sign, or you can, have the document passed around, but, individually. But I would suggest a electronic signature is more than sufficient. Nita G. Is the corporation allowed to request proof of address for newly added residents not listed as tenants or owners in order to obtain fobs? So everybody wants to know who's living in the building, and I think it's a safety and security issue. In addition, it's a obligation not of the manager or of the board, but it's the obligation of the owner to provide the information. I'm going to suggest that as a matter of safety and security, if you're not provided with sufficient information to satisfy yourself from a security point of view, you may want to consider not providing the fob. You're not going to give it to, you need to see ID. You need to see a deed. Some people will just say, okay, yeah, my address is the condo, and you're not going to be able to give them a lie detector test, so you'll have to give them the fob, but they've got to show you some ID. Nita G. Our fob policy is one per resident, and now the residents are adding cleaning staff. Well, I guess, Nita, you have a policy, and the policy is in place to keep control of the number of fobs. Perhaps you have to rethink the policy. If they have somebody coming into the unit, I guess they would pay for it. I know, unfortunately, today the actual copying of fobs is prevalent. It's better to be able to control the fobs and maybe charge them appropriately, or charge them a premium for further fobs. But I would suggest that the policy might want to be amended for cleaning staff, or people that living assistants, personal assistants. Let's say for older people, they may have people coming in to take care of them. So that's something that you should be taking a look at. Jean Lewis, can you have an election of directors where it is by proxy, that is to be submitted prior to the meeting, and not allow any nominations from the floor? Well, I'll tell you this. Our practice is to have a deadline for the submission of proxies, and we have that policy for a number of reasons. One is in order to be able to properly review and scrutinize the proxies. It's very difficult to do that when a meeting starts, for example, at 7 o'clock, and somebody, submits the proxies. Pre-COVID, it was you walked in with the proxies at 5 to 7. when the meeting starts at 7 o'clock and you give the registration table 200 proxies. So how are you going to properly go through 200 proxies when you have a whole meeting, number of people sitting there waiting for the meeting to start? You can start your meeting, but you certainly can't go to the elections and do a proper quorum count without reviewing those proxies. So for the purpose of reviewing them, I'm going to say you've got to have a deadline, number one. Number two, in the world of virtual meetings, you are going to be faced with paper proxies, and you're going to be faced with people voting electronically. My mathematical abilities are not great, but I'll tell you, if you vote by proxy and you vote by electronic ballot, 1 + 1 = 2. That means you've got 2 votes, and you're not allowed to have 2 votes, only 1 vote. So what has to happen is, as part of the electronic/virtual meeting, you need to very, very carefully review how many proxies have been submitted, who gave those proxies. You have to be super careful that when you set up your electronic links for the electronic ballots, that the only people that get electronic ballots are those that have not submitted a proxy. So you do not send an electronic ballot to somebody who submitted a proxy. All of this takes time. If you're going to have a proper running meeting, you need to, in advance, A, review the proxies for validity, B, ensure that you have a full list of people who have submitted proxies, compare that to the owner's list, make sure that you're not sending out electronic ballots to those that already have submitted proxies. I will tell you, in our experience, having studied very carefully electronic meetings, virtual meetings, and electronic voting, there are certain suppliers of electronic voting software out there, I'm not going to mention names, that are not checking, they're not cross-referencing proxies with electronic ballots, and people are getting 2 votes. I have seen this before. So you need to get a time, you need to balance what is appropriate to not to take people's votes away. So you need a time that's not too far away from the start of the day of the meeting so people can get proxies, but not so close to the start of the meeting that they can't be reviewed and properly collated and cross-referenced. So that's my answer. I hope I didn't kill you with that. Crystal Sen. Hi, Brian. Is it any penalty if the corporation missed the AGM deadline? Well, as everyone says in the condo business, there are no condo police. So no one's going to come to your door and say, knock, knock, you missed the deadline. It's not a good practice to miss the deadline. I don't see that there would be, a penalty. Of course, you want to have a reasonable, a reason why you couldn't hold your meeting on time. And, it's not because, we took so long to get our books and records, which were a mess, to the auditor, then the auditor took so long, and then we couldn't book a date. All of those things are not good reasons. Everybody should do things timely. However, I do understand that there's a real crunch now with getting your AGMs done on time, especially if you're in the first grouping that has to get them done, in October and November. Again, the good part about that is that the electronic, the bylaw for electronic voting and virtual meetings has been extended till May, so that's a relief. Nita G, thank you. All right, Nita, thanks a lot. Andy Tom. Unfortunately, our virtual AGM with your firm had quite a few technical issues. I wish we could have had a run through a few days ahead of time other than a half hour before. Andy, I don't know which condo you were with, but if you could send in an email, I'd like to follow that up because I know we've had great feedback. So I'm disappointed that you didn't have that great experience. So please make sure to send me an email personally, bhorlick@hldlawyers.com. I'm going to look that up and follow it up for you. Okay, and I appreciate your comment. All right, 2 directors and the PM had issues with their computers using Zoom. Well, if they had issues using Zoom, that wasn't issues with the software that we're using for the voting. But in any event, I want to hear what happened. because everybody learns from every experience. Nita, can a contract with no terms and termination clause be terminated for one-time/annual service? What should be the right notice of termination timeline in this case? So you have a contract that has no terms and a termination clause. No terms and termination clause. Well, if your contract has no terms, it's not a contract. It's a blank piece of paper. If you have terms but no termination clause, you have to, I guess, look properly at, when you were paying the contract and how you were paying the contract. For example, if you pay every month a certain amount of money for the service, you might want to impute that you need to give a month notice. If it's an annual service, I would say anytime within the year. You can say that you're not prepared to go forward, and to be on the safe side, you may want to give a 30-day notice. I think that's pretty reasonable. But if someone doesn't have a certain terms in a contract, sometimes the law will impute those terms based on the conduct of the parties. But I'm going to say that if you don't have any termination clause in there, and you've been using this on a yearly basis, a reasonable notice, 30 days, maybe 2 weeks, but that's about it. I think the law, when they interpret contracts, they interpret the contract against the party that drafted it. Obviously, in this case, it was the supplier. Next question. WC. Hi, Brian. For corporations that already have a date set before November 21, but have not sent out their preliminary notice yet, could the corporation now decide to postpone the date to before May 2021? So I think in this question, WC, there's a confusion. The extension of the date to May 2021 is an extension to be able to have an electronic virtual meeting with electronic voting. The May 2021 date did not extend the deadline for AGMs. So if your AGM needed to be done before November 21, it still needs to be done before November 21. The magic November 21 date, the magic there was that after November 21, you would need to have a bylaw in place in order to have a virtual meeting and electronic voting. So these dates do not affect the obligation to have your AGM as per the suspension period. So again, what the suspension period said was the legislation said there was going to be the period to have an AGM, which was 6 months from your year end, was suspended until such time as the emergency order was terminated. The emergency order was terminated July the 24th. And then you were obligated to have your AGM within 90 days of July the 24th. Unless your AGM date was going to be held in July, then you had another 30 days to hold your AGM. So it was going to be 120 days after July 24th. But this has nothing to do with May 2021. That only has to do with virtual meetings and electronic bylaws. Next, WC. Without any impact in regards to passing the virtual meeting and voting bylaw, do you recommend, due to the extension, that corporations should do it earlier than later if they are able to? Yes, I say 100% that if corporations are able to have an owners meeting and it's a one agenda item to pass the electronic voting and virtual meeting bylaw, you should do it sooner rather than later, because what's going to happen again is as we get closer to May 2021, there's going to be another crazy rush to have virtual meetings because everybody waited till May 2021, to move forward with passing their electronic voting and virtual meeting bylaw. So I would say, for AGMs right now, October, November, everybody is super busy getting AGMs done. I'm going to say December, January, February, that's the time. Do your electronic voting and virtual meeting bylaws. You can get them drafted now. and it's really if that's your only agenda item, your meeting's going to be super quick and you're going to get it done. The only thing I can tell you is that if you still have your AGM coming up prior to May of 2021, you can always take the bylaw, the virtual meeting electronic voting bylaw, and put that on the agenda of your AGM, and you do the vote right there at the AGM. You add it as a voting item, and so that will save you an extra meeting. Do it at your AGM if your AGM is before May 2021. Next, Leo Alvarez. Is the board obligated to allow a dog in a no-pet building to a unit owner who presents a letter from his family doctor stating that his son has depression and needs a pet? Leo, your question is making me depressed. So listen, the issue here is an issue of accommodation for a disability. If somebody has a disability, there's a duty to accommodate that person. And for a lot of people, the accommodation is a service animal, which has a lot of good effects on people with certain issues. And so if the dog is a service animal, then the dog is going to be staying in a happy home in your condo. That's what's going to happen there, Leo. Now, as far as human rights is concerned, it's incumbent upon the person asking for an accommodation to be part of the accommodation process. In other words, they have to provide you with sufficient information to show that, in fact, they do have a disability that needs to be accommodated. So they have to be part of the process, and it can't be any flimsy, certificate from, from some type of an organization that says, oh, this is a service animal. You need, or the corporation needs, the documentation, appropriate documentation from the medical professional to confirm that the person has a disability, and to set out how that the service animal is what is required to assist this person with their disability. So it's not any note, and it's not any doctor's notes. There is a case, it's the Dominelli case, which set out specifically what the requirements are for someone who is claiming a disability, and what the requirements are for the medical professional to fill out. Next, concerned owners. Hi, Brian. Last week, our condo board canceled the AGM at 5 o'clock, meeting to start at 6:30, due to what they reported in a letter was a release of the entire contact list of all owners to 2 candidates. There are hundreds of persons whose emails and phone numbers are now in public. What should the owners do? Well, I'll tell you, the email list, telephone numbers and emails are not part of what is required to be. It's not part of what is required to be provided to owners who wish to have a copy of the owner's list. So, owner's list is the name of the owner and their address for service. It does not include the phone numbers, and it does not include the emails, which are private. I think this is a matter that needs to be taken up with your board and to see exactly how this situation took place and what it is that they intend to do about this now that owners, really private information has been disclosed. Perhaps in addition to emails, there was phone numbers there, and it's not a good look, whichever condo you're at. It's not a good look what happened there. Again, speaking generally, you need to be judicious as a board and judicious as a community and as a condominium manager to let democracy take its place in condo corporations. And whoever you are in favor for or not in favor for is irrelevant. You want good people to run for your board. If you feel that people are running for the board that are not qualified, or there are less than admirable people, then what you need to do is run for the board yourself, or ensure that there are other good candidates from the pool of candidates for people to vote for. It's very important to have an election that is appropriate, transparent, and honest. Let's call it that. We were recently ourselves involved in a condo corporation where there was a battle royale, let's call it that, a battle royale at the AGM for different groups that were running. This is not unheard of in condominiums, and we did our very best to ensure that everything was done in a proper, transparent manner, that everything was reviewed, proxies were reviewed. We ensured the legitimacy of the proxies. It took a long time. At the end of the day, I presume the owners were happy because everything that could have been done was done to certify a proper election. But condominium managers should never get involved in anything to do with the election and the proxies. It's pretty well set out now in the new legislation governing condominium management service providers. They have no business to go anywhere near the proxies. It's not a good place to be. Managers are now licensed, and they are only looking for potential headaches if they get anywhere involved in that type of thing. You as a manager, if there's managers out there, I know you're listening, you must repel the pressure of existing boards for you to do things to assist them in maintaining their grip on power. No matter how much pressure is put on you, you need to, at the end of the day, just like a lawyer, you need to ensure that everything you do is above board and appropriate, because you are licensed, and that is the way you make your living. You worked very hard for that license. You're a quality professional, and you must never allow outside pressures to influence you. Next. All right, so those are questions. We'll wait to see if we get a few more. I'll just go back to the Reopening Ontario Act. So as you know, that was the act that that came into force after the emergency order, or at the same time as the emergency order was revoked / rescinded. Just so that you know, the police do have the authority to order that premises be temporarily closed if there are reasonable grounds to believe that an organized public event or other gathering is occurring at the premises that exceeds the number of permitted people. So police can come and shut you down. There's offenses now. We said this before. You can be guilty of an offense in addition to a penalty. If you are convicted of an offense, there's a fine, maximum $100,000 for an individual, maximum $500,000 for a director of a corporation, and maximum $10 million for a corporation. I don't believe you'll ever get into that stratosphere, but there are fines that you could be liable for. Penalties, which is more likely going to happen, you would be, as an individual, subjected to a fine of not less than $10,000, not more than $100. So you're guaranteed to lose $10,000 on this one. If you're a director, a fine is not less than $10,000, not more than $500,000. Of course, you also have terms of imprisonment, but we won't go there. And for a corporation, the fine is not less than $10,000 and not more than $10 million. So if you breach any of the orders, the social gathering orders, if you do things that are inconsistent with what the Ontario government is mandating, you can see $10,000 minimum going out the window. And if you've got $10,000 to burn, I suggest you give it to the charity that you love most, and then give that to charity, and then don't breach the rules, and everybody will be very happy. That's very important. You have to know as well that the corporation is the occupier of premises, and the occupier of premises is responsible for the premises, i.e. the common elements. If there's anything happening on the amenities, it's the condo corporation that might be looked to, or will be looked to, as an occupier. And regardless of who is having the party, I'm going to suggest that the person having the party or breaking the social distancing guidelines, or breaching the amount of people, 10 for the social gathering, not only will that person be look to for a penalty/fine, but so will the condo corporation. Now, a few more items before we close off for today. Just as everybody knows or may know, the Condominium Authority Tribunal, the CAT, has increased the type of disputes that it can now handle. So as you know, they've been doing records for the longest time, and now they've increased their jurisdiction. So not only can they handle records, but they can now handle provisions that prohibit or restrict pets or other animals in the units and the common elements. They can now handle disputes dealing with automobiles and motorcycles and assisted devices dealing with disability and bicycles, etc., in a unit or common element with respect to these items. And so parking issues will now be dealt with through the CAT, as well as parking or storage items will also, if there's disputes regarding parking and storage items on the common elements or in a unit that is for storage or parking purposes, that's going to be handled by the CAT. And now indemnification of costs back to the corporation for any of these items, if you have a dispute on the indemnification clauses, that's also going to go to the CAT. What is not going to the CAT is issues regarding Section 117 of the Condominium Act, which is dangerous activities. That is not subject to the CAT dispute. That goes to court. If you have a disagreement on Section 98, on a Section 98 agreement, the dispute on that agreement does not go to the CAT. That is a breach of the Act, perhaps, and that would go to court. Any issues with respect to electric vehicle charging systems will not be handled by the CAT. That again stays in the Condominium Act. And just to finish, what do we need to do to finish on a light note? Well, let's talk about DNA testing to track dog owners not cleaning up after their pets. So a recent article appeared. There's a townhouse development in Vaughan, yes. And the issue there was that due to the pandemic, many of the residents were buying pets. And unfortunately, the pet owners were not being responsible. And the common areas of this townhouse condo were littered with the waste from the animals. And the board was upset, and the management was upset, and the owners who unfortunately had to interact with this mess were upset. And so what this corporation did is they hired a company that is taking the DNA from every single dog, and they are storing the DNA, and whenever there is a dog incident, the evidence is collected and shipped off to this company who does a test on the DNA, which results in a chargeback to the offending unit owner. So I'm telling you, if you are a resident of Mackenzie Ridge Terraces in Vaughan, you're going to soon have exquisitely clean common areas, or you're going to have common areas that are not clean, but you're going to have money with which to clean that up. So this is unfortunate that you actually have to retain a corporation to do this. You have to pass a rule when all you want is a responsible owner taking care of his or her pet. Why is that so difficult? All right, I'm going to say one last thing. David Lella, I mentioned him before. He is one of our lawyers. He's a partner in our firm. David is, I would say, the best insurance lawyer dealing with condominiums, the best condominium lawyer dealing with construction deficiencies, including floods. He will be doing the AMA on October the 28th. I was able to convince him to please come on the AMA and help out all our loyal listeners. So October 28th, mark it down in your calendar. If you have any questions about floods, water penetration, building and construction deficiency, whether your building is new or old, remediation, mold, anything that could go wrong physically in your condo, David is an expert and he will be happy to present a number of interesting cases on the topic, and he'll be happy to answer all of your questions. So remember, October 28th, that's what you need to do. All right. We are now basically done. I see Julia Lurie is back again. I hope you were here for the entire episode, Julia, because I know Julia is taking care of her two little babies. She's on maternity leave from our office. We can't wait till she comes back in the beginning of November. We're looking forward to her. She's a crackerjack killer of a condo lawyer, and we are so excited she's coming back and looking forward to it. Ladies and gentlemen, we'll see you next week at our AMA at 12 noon. I want to thank you all for joining. Remember to visit our YouTube channel. We've got a number of various cases there that are being presented by our associates. So you want to take a look at that. And again, our FAQ is coming out every Monday or Tuesday, depending upon Doug Ford. If he's got something interesting to say, we'll hold it back till Tuesday. It's fully updated and something that you need to know as board members, as unit owners, residents, and condo managers. Thank you very much. I want you to have a great day and a great rest of the week. So long. Bye-bye.